Hello everyone, welcome to Quotes Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Syed Amir Hussain, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let's begin with the headlines and a concise overview of the top stories. After that, we'll delve into the full details, providing in-depth coverage and analysis of each update. Right to privacy petitioner and former Karnataka High Court Judge Justice K.S. Puttaswamy passes away at 98. Bail condition that accused shall furnish bail bonds 6 months after passing of order can't be imposed. Supreme Court. Bar Council of India removes 107 fake advocates from roles in Delhi. Police's action to take possession of immovable property without sanction of law reflects lawlessness, says Supreme Court. Karnataka High Court orders release of Union Minister Prahlad Joshi's brother-nephew, arrested in cheating case. Violent strike justifies immediate termination without inquiry, Bombay High Court. So far, 26 FIRs registered based on Justice Hema Committee report, State tells Kerala High Court. Let's begin today's episode with the news about Justice K.S. Puttaswamy, the former Karnataka High Court judge and the lead petitioner in the famous right to privacy case, which led to the Supreme Court recognizing the right to privacy as a fundamental right under Article 21, has sadly passed away at the age of 98. Justice Puttaswamy enrolled as an advocate in 1952 and was appointed as a judge of the Karnataka High Court in 1977. He served as a judge till his retirement in 1986, followed by a stint as the vice chairperson of the Central Administrative Tribunal in Bengaluru. In 2012, he became the litigant who challenged the constitutional validity of the Aadhaar scheme before the Supreme Court. Famously, though the Apex Court did not strike down the scheme, it made a landmark observation that the right to privacy would fall under the category of the fundamental right to life under Article 21 of the Constitution. The Supreme Court recently, on October 24th, dismissed 2 special leave petitions challenging the bail orders of the Patna High Court. It set aside the orders passed by the High Court and remitted the matter back to the High Court for a fresh hearing on merits, not before orally remarking that they have repeatedly witnessed bail orders passed by the High Court without assigning reasons. The SLP concerns 2 bail orders passed by the High Court on September 11th and September 19th respectively, wherein it imposed bail conditions that the bail bond would be furnished after 5 and 6 months of the date of passing the respective orders. The High Court granted bail to the accused on September 19th in connection with offences punishable under sections 30A and 32(3) of the BIHAR Prohibition and Excise Amendment Act. A bench of Justices Bela M. Trivedi and Satish Chandra Sharma, on being informed of the bail conditions, remarked that the judge passed the order not just without assigning reasons but also imposed such bail conditions. In the next important news, Bar Council of India, or the BCI, has removed 107 fake advocates from the roll of advocates in the state of Delhi. The action is being conducted under Rule 32 of the Bar Council of India Certificate and Place of Practice Verification Rules 2015. Between 2019 and 23rd June 2023, several thousands of fake advocates were removed after a thorough investigation into their credentials and practices. These removals are largely due to issues of fake and forged certificates and misrepresentation during enrollment. Besides, failure to actively practice law and non-compliance with the Bar Council's verification processes also make advocates' names removed from the active practice. However, with the amendment to Rule 32 on 23rd June 2023, the process became significantly more efficient. In the next news, in a recent case, the Supreme Court disowned the police's action to take possession of the immovable property by taking keys of the property under an application filed by the litigant. The bench, comprising Justice C.T. Ravikumar and Justice Sandeep Mehta, heard the matter and said, "We believe that this action by the police to take possession of immovable property reflects total lawlessness. Under no circumstances can the police be allowed to interfere with the possession of immovable property, as such action does not bear sanction by any provision of law." In this case, the appellants accused were alleged to have committed criminal trespass into the complainant's house and then constructed a wall to seal the entry of the complainants. The High Court, while granting bail to the accused, put a condition that the police shall carry out a demolition exercise of the wall at the expense of the accused. Also, the High Court directed the police to hand over the keys to the premises to the complainants after the completion of the demolition exercise. Setting aside the conditions put by the High Court, the court said that the High Court had exceeded its jurisdiction under Section 439 of CRPC by imposing onerous and unreasonable conditions relating to the grant of bail. That is, the direction for removal of the wall at the expense of the appellants accused and handing over possession of the disputed property to the complainant. Coming next, we have news about relatives of Union Minister Prahlad Joshi. The Karnataka High Court has directed the release of Union Minister Prahlad Joshi's brother and nephew, who were arrested in a cheating case for allegedly promising an election ticket to certain persons in exchange for rupees 2.5 crores. A single judge bench of Justice M. Nagaprasanna stayed all further proceedings initiated against them. Joshi, along with his son and 2 others, have been arrested by the police on a complaint filed by Sunita Chavan, a wife of former JDS MLA Devanand Chavan. It is alleged that the accused cheated her of rupees 2.5 crores by promising a BJP ticket to her husband for the Bijapur Lok Sabha constituency. Complainants had alleged that the accused had used the office of the union minister to promise an election ticket to them in exchange for the sum of money. In next news, coming from the Bombay High Court, a single judge bench of Justice Sandeep V. Marne upheld Advani Orlecon Limited's decision to terminate workers who participated in illegal strikes and violent protests without conducting a prior inquiry. The court ruled that where employee misconduct clearly jeopardizes workplace safety, as evidenced by the acts of obstruction, intimidation and assault, employers can justify termination retrospectively in court proceedings. The court affirmed that pre-termination inquiry is not mandatory when workplace circumstances make it impractical or impossible. In 1997, workers from Advani Orlecon Limited went on a series of strikes following unresolved negotiations over a wage settlement. This culminated in a violent demonstration at the company's gates. When the situation escalated to physical intimidation and the obstruction of other employees, Advani Orlecon terminated approximately 35 workers without conducting an inquiry. The termination notices cited the illegal strike and acts of misconduct as reasons. The court upheld the terminations, reasoning that the employer had acted within its rights under the MRTU and PULP Act, which is the Maharashtra Recognition of Trade Union and Prevention of Unfair Labour Practices Act. The court noted that where employee conduct clearly jeopardizes workplace order, the requirement for a prior inquiry is mitigated. In our last news for this episode, the Kerala government today informed the High Court that 26 FIRs have been registered based on the Justice Hema Committee report, pursuant to court's directions to the Special Investigation Team to take necessary action as per Section 173 of the Bharatiya Nagrik Suraksha Sanhita 2023. The state government submitted the SIT's action taken report to the special bench of Justice A. Jayashankaran Nambiar and Justice C.S. Sudha, which is hearing matters related to the report. In the last hearing, the court had observed that the report discloses commission of cognizable offences, which could be treated as information to take action as per Section 173 of the BNS. It had thus directed the SIT to register FIRs after conducting a preliminary inquiry. The court was informed that 26 FIRs are registered and the details of the accused are also shown in the FIR. It was also informed that 10 preliminary inquiries are being conducted and 4 other instances are being investigated by the SIT. For more details on the cases mentioned, visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Don't forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just ₹89 per month.